Logan Kelly, an officer working for the city of Farmington, state of New Mexico, did in fact violate 219 New Mexico Statute 66 Motor Vehicles Article 8 Crimes, Penalties, and Procedure, Part 2 Traffic Offenses, Section 66.8.123, Conduct of Arresting Officer Notices by Citation. A. The arresting officer using the Uniform Traffic Citation in paper or electronic form shall complete the information section and prepare a notice to appear in court specifying the time and date to appear, have the arrested person sign the agreement to appear as specified, give a copy of the citation to the arrested person, and release the person from custody. Release the arrested person from custody, if you would. Officer violating this section is guilty of misconduct in office and is subject of removal. Herein are the facts. On October 17, 2020, 1:19:10, Logan Kelly activated overhead emergency police vehicle lights on a 2011 Chevy Malibu for no 28. 12830 driver was issued Miranda versus Arizona, 384 U.S. 436-476, 1963. However, no citations were issued. 143:43 Logan informs driver, I'll let you get your stuff and get out of here. 143:50 Kelly asked Kelly Crawford if he had a license for the marijuana. Officer Jefferson placed on Kelly's patrol vehicle. Kelly was informed Kobe did not have a license for the marijuana. Kelly informs confidential informant Kobe Crawford, I'll let you put that back in your pocket. It's going to be a stressful night, I'm sure, so I'm going to let you keep that. Kelly released the driver of the vehicle from custody, stating, so you guys are free to leave at this point. Do you have any further questions for me? Well, I don't have any further questions for you. Do you have any questions for me? Defendant lawfully walks away from custody. Kelly attempts to justify his stop. They were leaving the roadway in, freaking no 28. However, I lit them up. I noticed the temp tag, but it was expired. Probable cause after the fact again, but whatever. I didn't write her citations, he states. Kelly then asks Officer Johnson, can I go stop her again? At 147:50, Kelly states to Officer Jefferson, because that's my PC. Should I just go stop her? Kelly then enters his vehicle, leaving the scene of the 2011 Malibu to re-pursue its driver that has been lawfully released from his custody and was in fact at 149 and was on foot rather. At 149, Kelly's overhead emergency lights are redeployed. Kelly exits patrol vehicle and states, sorry, Destiny, I forgot to give you your citations. Because I did that, I'm not going to even waste your time summoning you into court. If you guys want, my cameras, everything, I can place you in handcuffs if you want to sit in my car. If you want, it'll take 5 minutes unless you want to stand outside. 154:12, Kelly calls Jefferson and asks, can you run that 28 to the card so I can put it on the ticket? At 2:01:28, Kelly explains to a supervisor, I got him, i.e. Kobe Crawford, with the car, and I drove away without them signing citations. So, the supervisor states, say what? Kelly responds, I drove away without them signing cites, but they're super relaxed. Kelly states, I'll talk to you in a second. The supervisor states, okay. Kelly responds, yep, I appreciate it. I will need that supervisor's name and badge number. Relaxed or not, State versus Chamberlain, 12, New Mexico, 723-728, 319 PD 2D 673-678, 1991. A suspect is considered in custody if a reasonable person would believe that he or she were not free to leave the scene. United States vs. Long, 866 F2D 402 405 11th Circuit, 1989. Custody exists when a reasonable person would not have believed they had no choice but to submit. United States vs. McLean, 35 F3D 692 697 2nd Circuit, 1994, or where the interrogation is no more than a veiled attempt at eliciting an incriminating statement. United States vs. Bastap Blanco. Taken on its face, it is clearly established Kelly released the driver. Relinquency in exchange for signing a warning citation establishing his probable cause for his initial stop, and eventually search warrant issued upon the vehicle. State vs. Dina. He violated Miranda versus Arizona, 1966 motor vehicle, and we note specifically E. Any officer violating this section is guilty of misconduct in office and subject of removal. State vs. Wagner, 1998, and MCA 124126, New Mexico 9966 P2D 176, Wagner 2, if you will, or Wagner 1 at that point, I think it is, because this one's Wagner 2. As stated, New Mexico court believes that Article 2, Section 10 of the New Mexico Constitution prohibits them from retroactively and hypothetically correcting the errors of the police at the expense of a defendant's right to be free from unreasonable search and seizure. The state has transgressed the constitutional rights of a person accused of a crime. We will not sanction that conduct by turning a blind eye. More specifically, the court intended that the holding would, 1, provide a bright line rule for the law enforcement officers and courts reviewing police conduct, and 2, properly effectuate on individuals' right not to have evidence gained by exploitation of a constitutional violation used against them. Respectfully requested Logan Kelly be removed as per 219 Section 66-8 123E. Criminal offense Article 4, kidnapping 34-1, Article 4, Section 34-3, false imprisonment. Note, we respectfully request the supervisor in conversation with Kelly at 20128 be added to this complaint.